Hey everyone, I'm Attractive Nuisance, and thanks for joining me today for the next part of my series on the US Constitution. Today, I'm going to attempt to tackle the leviathan of constitutional issues, freedom of speech. More specifically, the First Amendment of the US Constitution, which prohibits Congress from abridging the freedom of speech. Courts have, as they tend to, grappled with what this amendment actually protects. And I'm not really sure about you, but I'm not super optimistic about the legal outcomes when courts can't even agree on what speech is. Yikes. There are a lot of doctrines underlying freedom of speech in the US, and each one analyzes what exactly is being regulated or banned. Broadly speaking, though, the First Amendment has been found to apply to vague or overbroad laws, content-based regulations, content-neutral regulations, compelled speech, and symbolic speech. Then there's also a different test depending on the forum of the speech, so speech can take a lot of different forms under the First Amendment. But as one of my law professors used to say, if it looks like a duck and it quacks like a duck, it must be speech. When we think of freedom of speech, we often think of it as being able to say whatever we want to whomever we want at any given time. But for better or worse, it's entangled in far more than just individual speech. For example, let me just scratch the surface of freedom of speech issues that Trump has inserted himself into. So we've got the recent campus protests over the war in Gaza that Trump has sought to deter, and he used some very colorful words to describe how he feels about them. Then we've got the recent TikTok ban, not ban, that while Trump insists was Biden's idea, it was really Trump's idea in 2020. And then there are the restrictions on schools from teaching gender ideology, discriminatory equity ideology, or critical race theories. And any schools that fail to conform to those ambiguously worded restrictions lose their federal funding. And I don't even want to get into all the times that Trump has or has expressed interest in punishing, and in some cases even prosecuting, journalists, reporters, and publishers, like how the Associated Press was banned from presidential events because it continues to use Gulf of Mexico instead of Gulf of America. And this trend has persisted beyond banning certain speech, and it's led to the forcing of media and online platforms to include conservatives' preferred speech in their content. And maybe you're saying, well, hey, Trump did sign some executive orders to protect speech. Sure, he signed those orders like the executive order titled Restoring Freedom of Speech and Ending Federal Censorship, which sounds great. But this is only a guise of protection that isn't actually supported by Trump's actions. If you've read any of the alleged free speech executive orders, you'll see a strange pattern of the orders condemning conduct that has been engaged in by Trump himself. And the language of that executive order bans federal resources from being used to, quote, unconstitutionally abridge the free speech of any American citizen, end quote, which gives Trump the power to choose what he considers misinformation or disinformation, and that tends to be whatever he just doesn't like. The executive orders then grant Trump the authority to punish those who says things he doesn't like, and the intent of these executive orders is to essentially erase any woke, racial, and gender messages. If you want more constitutional content on that topic, head over to my other video on executive orders, meritocracy, and DEI. So now that we've set the stage, let's dive into the bread and butter of this conversation. But first, I want to do my game mention for this week's video. So set in a medievally era, Bellwright is a picturesque survival game with colony building aspects. I haven't actually played the game yet. It's currently early access on Steam for PC, so I've been watching its evolution with curiosity, but I'm not sure if it's worth the $38.99 right now, especially for an early access version. But it does kind of look like it diverges from your typical survival games, and it has almost like a Zelda-like open world adventure vibe. So is it worth it? Is it any better than the similar games to it? If you've played or if you just looked into it, let me know your thoughts on its gameplay. I know there's a big update dropping soon, so maybe after that I'll feel more compelled to get it. I guess we'll see. The most compelling piece of Bellwright that really allures me is the freedom that it seems to offer. You can play in whatever style you want. You can choose to have more combat, more survival, more colony building. And as I'm sure you picked up on by now, I'm very passionate about freedom. Freedom to build, freedom to explore, and freedom to speak. So in the US, speech can be very generally divided into two categories. So there's speech protected by the First Amendment and speech that's not protected by the First Amendment. And then there are the kind of but kind of not protected by the First Amendment kind of speech. But for the sake of brevity, we'll keep it at two categories. So the discussion on protected speech is a really ugly chain of case law. It's very arduous in law school and it has a lot of exception, and even more, it depends. But the TLDR is courts look at laws restricting speech differently, depending on whether the law is a content-based restriction or a content-neutral restriction. If the regulation is content-based, it must be necessary and narrowly tailored to achieve a compelling government interest. This standard differs slightly for things like expressive conduct, symbolic speech, vague and overbroad laws, but it's very similar in most respects, and most often it just changes one or two words and kind of has the same outcome in courts. And then we have these content neutral regulations, which tend to just muddy the water even more. Because of its complexity, courts have established a separate test that law school professors try to sell as intermediate scrutiny. And this test was first seen in Ward in 1989, where the city had established laws regulating the volume of music in a park. Ultimately, the court did find that the limitation was constitutional under the First Amendment, and that the city could lawfully impose such limitations. These exceptions to First Amendment protections became known as the time, place, and manner restrictions concept. A limitation on speech is constitutional if it's content neutral on its face and is applied, it leaves open alternative channels of communication, and it narrowly serves a significant state interest. So it sounds very similar to the previous test with a compelling government interest, but again, the verbiage changes just slightly to make it a little more complicated. Additionally, the US courts have established that forced speech, where the government requires that a person engage in some kind of speech, is almost always unconstitutional, and I find that very interesting at this current time. So any law that forces speech is reviewed under strict scrutiny, which, as you may recall from my previous videos, that requires that the law be narrowly tailored to serve a compelling government interest. It's very hard to argue that forcing someone to engage in speech is the only way to achieve something that's super important. So on the other side of the spectrum, we have speech that's not protected by the First Amendment, and this includes obscenity, incitement to immediate violence, fighting words, defamation, commercial speech. I can make another entire video picking those apart, but for the sake of this video, just know that they exist, and not everything is protected speech. The point is this: applying those standards, those legal tests, which are constitutionally derived, and hence the supreme law of the US, Trump's activities fail to constitutionally regulate speech. Courts, including a U.S. District Court in Maryland, have already found that Trump's orders criminalizing DEI programs and forcing agencies to prove that they don't promote DEI violates freedom of speech. Trump is using content-based and viewpoint-based discrimination to make decisions about what words and thoughts people can express, which means it has to be absolutely necessary to withstand constitutional scrutiny. I have yet to see a compelling government interest that can only be achieved by what Trump is doing to the country. And I'm pretty sure verified Twitter accounts don't count as a compelling interest. It's funny how the strict scrutiny test can be loosened when Trump wants to do something, but it's entirely unmovable when it comes to things like women's rights. Let's shift the perspective to Canada. Constitutionally speaking, under the Canadian Charter of Rights and Freedoms, Section 2B protects freedom of expression. This is already so distinct from the US perspective of speech and having to delineate what constitutes speech. Instead, in Canada, anything that is attempting to convey meaning is protected under Section 2B. And the rationales underlying the section of the Charter are democratic discourse, truth-seeking, and self-fulfillment. So when courts analyze Section 2B cases, they look at it from the perspective of these rationales. That is what informs their decisions and informs why they make the decisions that they do. Canada does, however, make a distinction between negative and positive freedom of speech. Unlike Trump, Canada doesn't make the distinction on whether he feels positively or negatively about it. Negative claims, the most commonly seen by courts, are those that assert that the government has unconstitutionally restricted expression and a remedy is warranted. And so a person can bring a negative claim for freedom of speech and argue that it was violated by this government action. Alternatively, positive claims are those that assert that the government should engage in some activity to provide protections for expression. These are extremely rare though, and no positive claim has actually succeeded in court yet under Section 2B, so it's kind of almost a moot point in Canada, and most claims are the negative claim, arguing that the government has infringed someone's freedom of speech. Dealing with negative claims primarily then, the courts have applied the Irwin-Toy test from a case from 1989, which notice that this case came out the same year that the US case Ward on content-neutral regulations came out. So the first prong of the Irwin-Toy test asks whether the activity in question falls within the sphere of activity protected by Section 2B. This prong has two aspects. It says whether the activity is expressive content at all, and if yes, whether the method or form of the expressive activity or the location of the expressive activity removes that protection. So the first prong is it attempting to convey meaning, and is it actually protected speech? So like in the US, things like obscenity would not be protected speech, and so the test would end there and the claim would fail. But if no, so it is a form of speech that is generally protected by Section 2B of the Charter, the test proceeds to the second step. And step 2 asks whether the impugned restriction on the expressive activity infringes Section 2B in either purpose or effect. And that gets really, really complicated, so I'm not going to dive into that because there's a lot of nuance and a lot of case law that establishes establishes what purpose and effect are. But if the answer is yes, then the restriction is an unconstitutional infringement of Section 2B rights, and the person would win their claim and be provided a remedy. So as you can tell just from that test and the summary of that, it can get a bit complicated very quickly. And there's certainly a lot more to it. But that's a general framework that courts follow in Canada for freedom of expression claims. It's a guided decision-making tree that affords judges the ability to use discretion while promoting things like accountability and transparency. And because it's so much harder to justify upholding an unconstitutional law, if similar laws were struck down using the exact same framework, this provides a lot of protection for Canadian case law and Canadian law. I'm curious what you think. Is the Canadian approach too inflexible and narrow to address every expression issue? Or is the US approach simply too haphazard and chaotic? I'd love to hear your thoughts on this issue, especially as things are heating up in the US and on an international scale. Freedom of speech is so personal to all of us, and it affects us all intimately, so it's such an important conversation to be having. Thank you so much for popping by onto this constitutional discussion today. I'm Attractive Nuisance. Don't forget to like this video, subscribe to my channel, Leisurely Law, and leave a comment with your thoughts on what you'd like to see more of. Speak up, or your silence will speak for you.